Well, hello, my name is John Watts. I'm a consumer protection attorney in Alabama, and I want to welcome you to our question and answer session. We've received a lot of really good questions. I've got a lot of those written down, probably more than we can cover in this session. So we may end up doing 2 sessions today, so the videos won't be quite so long. So the first question is, I have a judgment against me. What do I need to do if I want to pay that off? Well, in the context of this is a debt collection judgment. Now, it could be from an original creditor like Chase or Capital One, but some type of collection suit. And now this person has a judgment against them. They were properly served, so there's no basis to undo that judgment. So what do? Well, you can pay it off. Now, a couple ways to do it. One could be through garnishment. So if they're already garnishing your wages, you may say, I'm fine with that. Just keep taking out that 25% of my paycheck every week or every 2 weeks, however it goes. Or you can try to negotiate a lower monthly payment. It's not really appealing to the company that has a judgment, because if they can get $400 every 2 weeks, why would they agree to take $200 from you? But sometimes circumstances will allow that. But the most common way to pay these off is with a lump sum. So let's say you owe $5,000. That'll be our example. Maybe you can go to them with a $3,000 lump sum, and they'll agree to take it. There's a lot of factors. If you've been at your job 27 years versus you've had 27 jobs in 2 years. They might be more likely to take a lump sum if your employment history is not real solid. How much are they getting out of the garnishments? If they're getting a whole bunch, they may say, no, we'll just keep that coming. Or if it's a smaller amount, they may say, yes, we want the money. And then just a lot of times they do want the money. I mean, money in hand versus maybe you'll get payments in the future. A lot of times money in hand is very appealing. So here's a procedure I suggest. And we do something similar if we've been hired to do this, but if you do it on your own, this is what I would suggest. You want to get an agreement in writing. So in other words, how much do I have to pay on this $5,000 judgment to be done with this? Is that $3,000, $4,000, $2,000? What is that? That's what you want to do. Then make that payment. And usually it's easier if you do it by certified check, cashier's check, some kind of official check rather than just a personal check. And now the collection lawyer has to wait 7 days, 14 days, make sure that that's good. So once that is paid, then you want to make sure, that the collection lawyer, and you get this ahead of time, get this agreement, that when they get the money, they will file something in court. So they take a notice, and it's called a satisfaction of judgment. And all that means is there's this judgment out there, and if somebody's looking that up, they go, there's a judgment against you. But then they see this piece of paper and it says a judgment has been satisfied, or it's been paid off. So you've satisfied your obligation. And that lets the world know, yes, there was a judgment, but now you owe 0 on it. So $5,000 judgment, you paid 3, even though you didn't pay the full 5. If the deal is $3,000 and you're done, then they should file that satisfaction of judgment. Now here's the problem. Normally judgments will be on your credit report, but the credit bureaus are, how can I say this, either very slow or not particularly interested in updating your report to show that you owe 0 on this $5,000 judgment. So what we suggest people do is you get that satisfaction of judgment. That's filed into court. There's a stamp across it. It says it was filed on July 15 at 2:33 p.m. Great. So you get a copy of that. You send that to the credit bureaus and say, look, guys, you're reporting on page 1 of my Equifax report, or TransUnion, Experian, whoever it is. Usually it's all 3. But you're reporting that I owe $5,000. Please look at the form I've enclosed. You'll see I owe 0 now. Please update it. And usually if you take the effort to notify the credit bureaus, then they'll update it. But even then, sometimes they don't. And they'll keep that on your credit report. They know that that damages you, it harms you. Here's a simple solution. Assuming it's appropriate, and we've done this many, many times. You talk to a lawyer that does this type of work. So if you're in Alabama, we'll be happy to help you. And we file in federal court a lawsuit against the credit bureaus and say, you have false information on my credit report. And they go, but wait, you had a judgment for $5,000. We go, that's true. But look here, satisfaction of judgment, owe 0. You are doing false credit reporting by telling the world I still owe $5,000. And when we do that, the credit bureaus, they make all these excuses and arguments and all this stuff. But at the end of the day, they know if they've been caught, they have to delete that from your credit report. That's one of our requirements. Not just that it be updated, but we want the whole thing off. They got to pay you money and they got to pay us money. So they know that's the deal when they lose these cases. So if you're looking at paying off a judgment, that's my suggestion for what to do. Now our next question is similar. What if you've been sued? So you get a copy of the lawsuit, but there's no judgment yet. But you say, you know what? I just want to settle this. What do I do? Well, similar to what we just spoke about with the judgment, call the collection lawyer if you're handling this on your own. Get an agreement in writing. So again, say they're suing you for $5,000 and the agreement is you pay $3,000. Get that in writing. It could be a letter, it could be an email, but you want to make sure that it's very, very clear. We've had lots of cases where people pay the $3,000, the debt collector still comes after them for the $2,000, but there is no $2,000. See, I owed $5,000, I paid you $3,000, and that was the deal, so we owe 0 now. But if you don't get it in writing, they'll go, oh, I thought that was just a partial payment. No, let's make it very clear in writing. $3,000 and we're done with this lawsuit. And then you want to make sure that the collection lawyer dismisses that lawsuit with prejudice. With prejudice means they cannot sue you again. It's over. It's done. Well, is that the end of it? No, because you want to look at your credit report because Capital One or Midland or LV&V, they're saying on your credit report you owe $5,000. Well, if you settle with them for $3,000 and it's done, it's over, case is dismissed with prejudice, then your credit report should say you owe $0. Now, it can say that at one time you owed $5,000. That's fine. But now you owe 0. So just like we did with the judgment, usually what we want to do at that point is send a letter to the credit bureaus and say, look, you are reporting inaccurate information. And here's the reason why, because Capital One, Midland, whoever it is, they often won't update the credit bureau. Equifax, Experian, TransUnion. They won't tell them that you owe 0 now. A lot of times in their mind, you still owe them $2. And they may say, oh, you know what? We could sell this debt to somebody else. Well, so you want to catch this very quickly. So you write the letter and you say, my Midland account or Capital One or whoever it is, you say I owe 5, owe 0. If you have any doubt, check with Midland, Capital One. Sometimes you include a copy of the order dismissing the lawsuit with prejudice. And then it's either going to get fixed, or if it doesn't get fixed, you sit down with a lawyer. Again, if you're in Alabama, we'll be happy to help you. We do this all the time. We file suit in federal court against the credit bureau and the furnisher. The furnisher is the Capital One, the Midland, whoever it may be, who's doing that false credit reporting. Now, I will say this. If it's a debt collector, sometimes you don't have to do that dispute. Okay, there's some different laws. I don't want to get bogged down in that, but the point is, you were sued for $5,000. Now that's over. That's done. So you want your credit report to reflect that, not to show that you still owe $5,000 or maybe you owe $2,000 because they just took 5 minus 3 and they go, oh, you owe us 2. No, I don't owe you anything. 0, nothing. Make sure your credit report shows that. Okay, our next question is, why should I send a dispute letter to a debt collector by certified mail? And this was somebody that had seen that on our websites and videos and books, we always talk about if you're dealing with a debt collector and you send anything to a debt collector, do it by certified mail. If you're not going to do that, then you're just wasting your time. The reason is you can have the greatest, whatever it is, letter, settlement proposal, well, I don't care what it is. Anything you're doing with a debt collector in writing, and you could have the most perfect letter. And that debt collector gets it, looks at the envelope, says, huh, not certified mail. Just throw it. Just chunk it. It's no good. And then, maybe that was a cease and desist letter. Hey, do not communicate with me anymore. Well, once they get that, they can't call you again. But they'll keep calling you. And you go, wait a minute. I sent you a cease and desist letter. They go, what cease and desist letter? We never got a letter from you. You go, yeah, I put it in the mail. It got to you. It never came back. They go, well, we never got it. Well, how do you prove that? You really can't. So you do it by certified mail. Because when they lie about not getting your cease and desist letter or your dispute letter or whatever letter it is, when they lie about that, you pull out this green card and say, right there, you signed for it. And then it's funny to watch them squirm. Because they'll say, somebody stole the certified mail. Really? Somebody stole the certified mail from you. And then they go, well, maybe they didn't steal it, but it got misplaced. That's not our fault. Actually, it is. Because you got the green card and you lost it. It's not my fault. It's your fault, debt collector. So it's interesting to watch, and it almost always happens. There's this progression. We never got it. We never got it. Maybe we got it. We lost it. When you said don't ever call me again, we didn't know what that meant, so that's why we kept. They just go through this progression of lies. But you've got to do it by certified mail. $7, I think. It's worth the money. If it's important enough to contact a debt collector, it's important enough to do it by certified mail. And by the way, this applies to credit bureaus, really anybody that you're communicating with. We kind of joke about, what is certified mail? Well, the expression we use around the office is no good news comes by certified mail. What do we mean by that? Just mean certified mail is, this is not always true, but it's true enough. When you are sending a letter to somebody and you think that they will lie about getting it, so you want to prove that they got it, that's when you do certified mail. Now, you can also do FedEx, you could do UPS, Priority, just something that has a tracking mechanism in it where somebody has to sign for it, or somebody saying, hey, I delivered this. But the safest thing is certified mail. All right, so our next question is, I got sued, and then the debt collector or debt buyer, somebody like Midland, LV&V, Portfolio Recovery, Asset, Unifund, all these types of companies, that company dismissed the lawsuit without prejudice. And so the question is, what does that mean for my credit report? Well, let me back up, make sure we're on the same page. A dismissal with prejudice means case is over. Now, it could be because you settled, or it could be because they realize they can't prove their case and they just dropped the case. With prejudice means they cannot sue you again. Now, we have a situation right now where a case was dismissed actually by a jury or a verdict, not a jury verdict, but the judge ruled in our client's favor. And then they sued us again on the same debt. It's like this completely outrageous thing that this debt buyer, Main Street Acquisitions, did. But let's put aside companies that will do things that absurd. Dismissal with prejudice means it's over. They can never sue you again, or at least they should never sue you again. Maybe companies like Main Street, they struggle with that concept. But most companies get it, that dismissal with prejudice, it's over. Now, where they stumble is they don't understand, and I'm taking this outside the settlement context, dismissal with prejudice, they got to get this thing off your credit report. Under most circumstances, they can never call you, write you about it, all sorts of stuff. But what about if it's without prejudice? Well, without prejudice means it's almost like the lawsuit never happened. So the next day, the next month, the next year, they can sue you again. And that's not a problem. Now, that new lawsuit, they have to make sure it's within statute of limitations, that it's a legitimate lawsuit. But the fact that back here, they sued you and dismissed without prejudice doesn't prevent them from doing it again. They can sue you again. So in and of itself, a dismissal without prejudice does nothing for your credit report. See, with prejudice almost always means they got to get off your credit report. But without prejudice doesn't mean that. But here's what it does mean. If you were sued, so you get a copy of the lawsuit, you file an answer and say, I deny owing Midland, Main Street, Unifund, whoever it is, I deny owing you this debt. Well, that's a dispute. And then if that company is credit reporting, and at least if they update your credit report, I won't get into all the details about what if they don't update, but if they do update, and almost all the companies that credit report, they do it every single month because they want that fresh notation on your credit report, so it'll be the most damaging possible to motivate you to pay the money. So if it's without prejudice, but you filed an answer denying it, and then they update, they have to show your account as being disputed. And we've had them say before, well, that wasn't a dispute letter. We're like, seriously? I mean, a pleading in court, filed in the court, that's an answer? That's like the ultimate dispute letter, okay? So we don't get those arguments, at least not very seriously. They'll make them a kind of on the front end. They go, okay, yeah, I know your guy disputed. But if they don't mark your file as being disputed on your credit report, you can sue the debt collector under the Fair Debt Collection Practices Act, the FDCPA, and it's a subsection called E8. It has to do with credit reporting. So to answer this question, sue, dismiss without prejudice, what does that mean for my credit report? In and of itself, it doesn't mean anything, but probably you filed an answer, so we have to check your credit report. And if it's incorrect, then we look at suing these guys. So I hope that that's helpful to you. I think this will be our last question, at least on this video. The question is, do I have any recourse if I pay a higher interest rate because of false credit reporting? And the answer is probably. So let me kind of walk you through it. If we're talking about a debt collector doing false credit reporting, then the answer is yes. There's statute of limitations, there are other issues, but normally you can sue under the FDCPA, the Fair Debt Collection Practices Act, for false credit reporting. But what if it's Capital One? What if it's the bank that you took out your mortgage with? What if it's one of those companies, and let's just assume they are not a debt collector, so they're not subject to that FDCPA, Fair Debt Collection Practices Act. Well, you can sue under the Fair Credit Reporting Act, but generally, not always, but generally, you have to prepare a dispute online, over the phone, or what we suggest in writing, and you have to give that to the credit bureaus. That's Equifax, Experian, TransUnion. And then after that, they have 30 days to investigate. And if they don't fix it, then at that point, you can sue. At that point, you have damages, okay? But it can get a little complicated. Can you go back in time and get damages? And, that's a legal issue that there's a lot of moving parts to that. I don't want to get bogged down in this video. But I'll just say this. Anytime you see false credit reporting, you want to take action. If it's a debt collector, maybe you can just go ahead and sue them. And that tends to get them to fix it right away. If it's not a debt collector, dispute it. Even if in the past this cost you a higher interest rate, go ahead and dispute it. Get it fixed now. And if it gets fixed, then we can talk about it. If you live in Alabama, we can talk about, can you still sue that company or the credit bureau? But if you dispute it and they don't fix it, then we can certainly look at suing them in federal court. And then it's some legal issues about can we go back and sort of pick up those damages, okay? And I'll give you an example. Let's say you refinance your house, and because of errors on your credit report, you get 7% interest. If those weren't on there, you would have got 4% interest. Well, that's a pretty good spread. Well, but you don't realize this, and then later you dispute through the credit bureaus, and they don't fix it, and then you sue. Can you go back to and get damages for paying 7 instead of 4? Maybe, maybe not. But you could always try to there's an expression called mitigation of damages. So here you are, try to get another loan. And if that loan comes back at 7% or 8%, well, now you have your damages. So again, there's a lot that goes into that. But the point is, if you are paying more, higher interest rate than you should be paying, and the credit bureaus or Capital One or debt collectors, whoever it may be, if these guys don't follow the law, then normally you have the ability to file suit. And then it's just a matter of, well, exactly what damages can you get out of that? So I hope that this is helpful, and this whole series of questions on consumer-related subjects has been helpful. If you live in Alabama and you want to chat with us, 205-879-2447, or you can contact us through alabamaconsumer.com. That's our primary consumer website, and we'll be happy to set up a meeting or set up a phone call with you and go over some options with you. So thanks again for watching this, and if it was helpful, feel free to like it or share it or comment, and that'll help us to spread the message. Thanks. Have a great day. Bye-bye.